Members of the committee, staff of Parliament, invited guests. We do not as yet have a quorum. Ralph Thorne is on the way, but in the interest of moving things along, and as much as we're not making any decision, we felt that we should begin to receive the submissions, and I therefore propose to proceed in the order in which individuals indicated they wanted to appear before us. And that would therefore be Mr. Marvell, then Mr. Williams, then followed by the Barbados Bar Association. The other matter relates to the request of the bar that their photographer be permitted to take a photograph or two during the proceedings. I don't believe there's any difficulty with that. Then you will go face the back. There being no dissenting voices, we would agree to Mr. Giles taking a few photographs during the committee proceedings. Without any further ado, therefore, I'd like to invite Mr. Marvell, who is an esteemed Barbadian, a former diplomat, and a distinguished former senator who therefore sat in this chamber, to make his presentation. By way of how we proceed, Mr. Marvell, we will give you up to 15 minutes to make your presentation, and then the committee, if they feel necessary, will engage you for clarification or your further thoughts or comments. Over to you.
Thank you, Mr. Chairman. Good afternoon, distinguished members of the Joint Subcommittee. I perhaps should say something about myself in terms of this particular operation and others. In fact, I spent the first years of my adult life as a teacher, teaching in 6 different countries, including Barbados. And all the rest of my adult life I spent in the service of Barbados. I was a diplomat for most of that time. I also worked in the Ministry of Education, and I was a senator. I also taught governance at the university for about a decade. So I'm not unfamiliar with the subject. Then suddenly, for some reason not known to me, Prime Minister Thompson asked me to look at a suite of integrity legislation. And we worked on this thing and came to some interesting conclusions, but at his death, most things went into file 13. Integrity legislation was left hanging somewhere. The other aspects of this suite of legislation which I would hope to see are the question of a contractor general. This was blocked by 2 permanent secretaries who said they were working on something, and then of course nothing happened for 10 years. The freedom of information, which I think is one of the fundamentals of democracy, that ended up, I think, among the CPP, who decided that it would kill the secrecy of the civil service, which is what it was intended to do anyway, and that you couldn't have a freedom of information. But there are freedom of information acts all over the region anyway. Then there is the Defamation Act, which was stopped by a minister, although he accepted that it was the one law where you were guilty until proven innocent. I have always thought that one should be able to offer an opinion on any public figure without fear of being criminalized. if I said that the minister responsible for Moonlight is an idiot, that should not be an offense, if you get my drift. With respect to other things that I believe that are important to the process, one is an ombudsman. And the ombudsman, I mean the ombudsman in the sense that there is such a person in the Scandinavian countries and in Germany who is not responsible to anybody other than the ordinary citizen, who cannot be removed from his post unless there is some malfeasance, he does something terrible. And finally, well, not finally in that sense, but I think it's important to have a standalone whistleblower law. And this must cover whistleblowers in the public and private sector. I also believe that private sector figures involved in corruption should also be charged, unless that person is a whistleblower. Getting to the actual bill that is in front of us. Oh, by the way, I do not have with me copies of the other bills, but I noticed that this one is the same one that I worked on initially. The suite of bills was drafted by Professor Fiaggio, so they're available, maybe, sir, in your office or in the office of the civil servant. Yes, I think by now we are probably agreed that a simple integrity law will not work on its own. I believe Sir David Simmons made that point before, but he was looking at only the addition of the freedom of information, I believe. I think the Contractor General is terribly important in this context because contracts are areas where there can be corruption unless there is proper coverage. The Contractor General law in Jamaica works beautifully. I have no reason to believe that it wouldn't work equally beautifully here. There are some things in the present legislation which I would like to have a say on. On page 23, the fine or the ceiling for gifts is $1,000. I think that is rather high, for the simple reason that you don't have to reach $1,000. You can go 900 several times. I would prefer to see a low enough ceiling to make it extremely difficult to give gifts in return for favors. I would prefer to see about $200 rather than 1,000. The list of, you got that? Oh, the list of persons covered in public life. What we began with is there in the document. That is, the heads of government services, permanent secretaries, chief executive officers of corporations, etc. But I think that is rather missing two huge chunks of possible corruption. I think that all customs and police officers ought to be included in that list. Whereas it's extremely difficult for somebody, some minion in the Ministry of Education, let's say, to be corrupt in any real sense, because whatever he decides would have to be decided by the permanent secretary at least. In the police force or in customs, it is terribly easy for anybody at any level to be involved in corruption of a major scale. There was also the issue of a code of conduct, which I don't see in the present legislation. This was a code of conduct to be drafted by the ministers themselves so that it would not be totally unreasonable. I know that you have read the article I wrote on this, And in the case of South Africa, the code of conduct requires you to declare any gifts that you have. As I explained once, I sent to an old friend of mine, I sent 2 bottles of old Bajan rum. And a few days later, in the newspaper, it said, Mac is so much under pressure that his friends are sending him rum. You know, I mean, that's the sort of thing that I believe would be very healthy. The fact that people in the press can comment on things like that they do comment on them, even if they do so in fun. There was one other issue, I would say, in the question of the choice of a head of the eventual tribunal. I am less in favor of a combination of the Prime Minister and the Leader of the Opposition choosing such a person. I would always prefer the Governor General, because in my experience, whoever the Prime Minister is has the upper hand. And therefore, you might have a situation where there is not any precise justice in the choice. The Defamation Act, I think it is necessary to have that because you need to have the measure of freedom of speech, which allows people to be critical, which allows further investigation into something that they may know something about, but don't dare say. I'm not sure how you view these things, but I will take a time out at that point and speak to anything you need to have me speak to.
Thank you very much, Mr. Marville. The panel is asked now to engage. If I might go first, though, I do have to say that your recommendation that all customs officers and policemen should also be subject to the integrity and public life.
I'm sorry?
I believe you're recommending that all customs officers and policemen should also fall under the rubric of this bill, correct?
Right.
Yeah. I unfortunately stepped away for the moment while you were discussing that.
Yeah.
I wonder whether you don't consider that there are a large number of police officers, constables, who might not appropriately be targeted. In other words, do you think we need to extend the net so wide as to include officers of junior ranks?
Yes, sir. I don't think it is a matter of rank in the police force. It is a matter of situation. In other words, if a policeman of whatever stature is dealing with drugs, there's a possibility of corruption. If he's dealing with drugs and guns, let's say, and that terrifies me. In the case of customs officers, I'm afraid I don't know what to say. You know, there's a possible corruption at practically any level where somebody is in a situation able to release goods. I don't know if
Senator
yeah.
Senator Cummings?
Thank you very much for your submission. You've covered quite a number of areas which are quite far-reaching, and I think we are appreciative of the breadth of your presentation. I do want to follow up on the question raised by our Attorney General with regard to police officers and customs officials. What would be the specific recommendations that you would make in this instance with regard to customs officials, obviously as distinct from how you would treat to the police force? I'd like to hear a bit more from you on that.
Well, I think in both cases, it does not have to be every police officer or every customs officer. Police officers who work at headquarters, just sort of going through routine issues, do not need to be covered. But police officers who are out on the street, dealing with guns, dealing with drugs, etc., need to be monitored. I have other theories about such police officers. I think because of the danger of what they're involved in, they ought to be specially treated.
Well, as it relates to customs, I'd like to hear the specific recommendations, because in principle, you have customs officials who are functioning not just at points of entry and exit, but they're also functioning at people's homes with regard to unstuffing of containers and those kinds of activities. So they are interacting with the public.
I think in the case of customs officers, I don't know what the limit is. I think somebody who is actually much more directly involved in customs should be looking at this and saying, okay, we can't take all customs officers, but we can take a specific number of them, or a specific area of customs officers.
Sir, I have a little difficulty understanding your recommendation in regards to the customs officers and police officers. You know, customs officers are people who work in customs, from the guard to the control of customs, according to the customs legislation, can be regarded as customs officers. Where will you cut off? We already have legislation in place to deal with corrupt public servants, corrupt public officers. And I'm surprised that it is not being used. It is not because it is not being used that you should now lump them in with something else. You should enforce the legislation that you have already. Are you aware that there's already whistleblower legislation in the Public Service Act? Most people don't. See, but that's what I'm telling you. Recommendations are not going to be helpful, especially if you're going to have 400 customs officers that the commissioner has to review. You know, this legislation started out by as to deal with corrupt politicians. You know, that's what it's all about, and it's becoming a hydra-headed monster. You know, everybody wants it, but everybody else in left with the judges, though. You know, and there are people who should. They have more opportunity to be corrupt than most people. You see, I do not agree that you want to go down to the customs office and lift out the police in the office and stuff, because the police in the office can be sent next week, but the commissioner changing his duties. So I suspect leave the police force where it is, control them by use of the police legislation and the public service legislation, same thing for customs. Leave them out. We got too many people already in this. As a matter of fact, even independent senators and opposition senators are included in this legislation, and we don't have any avenue to be corrupt. How are we going to do it? You know, but everybody just throwing in things because somebody might have a bright idea. The idea isn't so bright, sir. I'm very sorry.
I resent the suggestion that everybody is just throwing in things. I do believe that when people make suggestions, they just don't throw them in, they think about them seriously. I made the point that in the case of the customs and police officers, what scared me most was drugs and guns. And if you're not prepared to believe that these things pass through, then we are not living in the same world.
That is not integrity in public life that we are dealing with. That's the criminal law that we have already in place that can deal with those people. We have the Customs Act, we have the Police Act. That's what I'm saying. People just throwing in things without understanding that there are other pieces of legislation, other laws that adequately deal with these. The problem here, you know, a lot of our problems in Barbados is enforcement, you know. Not necessarily another piece of legislation, it is enforcement. So I think we already have too many people in this integrity of public life thing already, and I don't think we should need to expand it to customs, police, and next thing you're going to hear, if you don't pay the firemen something, you're going to let your house burn down. You know, this thing is going too far now. We want to get the politicians who have been taking bribes for years, forever and ever and ever and ever, starting in here, coming in here as paupers and leaving as multimillionaires. That's what we want to deal with, Not, I don't want to give you a list now, but I have a list. Even in the last administration. But because we are not here for that today, but leave the civil service, leave the police force, and enforce the regulations. The problem in the police force and the problem in the civil service is political interference, because you put politicians into these jobs, and then they don't do the job because people can do favors to people. It is political interference that causes the corruption in the police force and causes the corruption in customs, Right now we have a customs officer, never been a controller of customs, never worked in customs before, getting the job. That's the problem.
I am afraid that in some cases, it is private sector interference. I will not go into details, but I do know of a specific case, and I'm not talking about it.
I know
So what do we do then? I think personally that we also have, in any conviction of a political figure, there is a partner in the private sector, and that partner should also be judged.
I agree, 100%.
Good.
Thank you very much, Mr. Chairman. Good afternoon to everybody. Thank you, Mr. Marvel, for coming, taking your time to make the presentation. Could you detail perhaps just a bit more for me your concerns or perhaps your suggestions relative to the role and function of the Office of the Ombudsman? You expressed some concern about there being independence relative to the functioning of that office, but you did seem to suggest that the role of that office needs to be enhanced and strengthened. Could you deep a bit more?
Yeah. The word, which is a Scandinavian word, ombud, means message, or that a man who's carrying a message, and the man is carrying a message for the ordinary citizen. In several cases, the ordinary citizen is up against a powerful government, a powerful private sector issue, and he does not have the means to hire a lawyer to fight that. That is where the ombudsman ought to be able to make an input. And I think more important than that, or as important as that, the ombudsman has never been a totally independent person. He can be moved at the will of the government. An ombudsman in Scandinavia can only be moved if there is some malfeasance involved, or if he's reached an age that they consider a retirement age. Does that satisfy your question, sir?
What would you do to enhance the independence of the office and the person performing that function? You made a reference to how the office is resourced. Any suggestions as to how the office of the ombudsman should be resourced as to contribute to the degree of independence that the office enjoys? And what else can we do to enhance the function of that office such that independence is ensured and the office actually made to be more relevant?
Well, look, the nature of the ombudsman as he is now, or as she is now, is such that the ombudsman can be moved by government because the ombudsman was placed there by government. I'm a little bit different in these respects. I would always prefer to have somebody put in a position like that by the Governor General, who is a neutral political force. However you look at discussions and agreements, the party in office will always have the upper hand. Okay? That is one way of creating greater independence for the ombudsman.
Thank you, Mr. Marvel. One of the purposes, obviously, of the select committee is to receive submissions and to hear the oral inputs and written inputs of members of the public and interested stakeholders. And you have submitted to us a written piece which covers quite a number of things. And it didn't cover one thing which you just raised, but which we have heard from other partners and other stakeholders who have presented at our previous sittings. And it spoke to the relationship between the Integrity in Public Life bill and the private sector and the fact that it's missing from the legislation. What would be your recommendations based on your experience for the treatment of issues relating to corruption of public officials by those in the private sector? I think certainly our Prime Minister always says it takes two hands to clap. So what would you say should be done?
Make sure that both clapping hands are involved in the judicial process. I think it is only fair, because if you have a situation where we decide, okay, ministers are corrupt, and those are the people we go after, or public servants are the people who are corrupt, and those are the people we go after, what happens in the private sector? In the US, for instance, all private sector operations are governed by a notion that they will not involve other people in bribes to get something. I don't know that we need to go into the business of specific legislation, but certainly if we have somebody who is a minister who is corrupt in a certain situation, he's not corrupt or she's not corrupt on her own. And therefore, I don't think it's fair that the person who is involved at the other end should go scot-free.
Thank you, Mr. Marvell. I take it from the terms of your presentation that you are of the view that integrity in public life is only one of the wheels of the vehicle that will allow our country to run smoothly. And I don't think you will find any disagreement from anyone around this table. But in terms of your other recommendations, and while they're not before this committee, I wonder if I could canvass your views on the matter of freedom of information. I can say to you that freedom of information is something that is being committed to by this current administration, and I'm aware that there was an effort to draft. In fact, I think that there was an effort to actually get a draft ready under previous administration. I wonder, though, if you have any thoughts on the ability of an already challenged public service to meet the potential needs of an inquiring public. It is near impossible to get any quick response from the public service on any of the routine matters that they do on a day-to-day basis. And it would seem reasonable to me that a request for information on a town planning file that dates back maybe to 2015 or maybe even earlier might require quite a bit more of the public service. And I'm wondering if we have given any thought to the balancing act that we have to do. Something is a desirable outcome, but the desirability of that outcome has to be balanced by the ability of the public service to satisfy that request.
Thank you for that question. One idea was that the Government Information Service collects information and puts it out. They have members of staff who are familiar with the matter of information. They would be excellent information officers within the system, rather than going out and looking for completely new people or using people within the system as it is. That's one possibility. we had done a lot of work on this. In fact, the Freedom of Information Bill had gone the furthest. It was right up to the point where it should be drafted, redrafted as a bill for Parliament. We took it out to the public all over Barbados, not all over Barbados, in about 4 or 5 different places. And there was invariably approval for it. Nobody said, oh, no, why do we have to have freedom of information? They understood the point of it. And as I said, this is, if you look at the declaration, the Atlanta Declaration, you'll see that this was considered by a vast number of countries meeting there to be a fundamental in democracy. People need to know what is happening. You can also, of course, discard frivolous inquiries. If somebody,
Frivolous to you might not be frivolous to the inquirer.
well, somebody will come up and say, look, is it true that we're going to have an epidemic of measles next year? That is a frivolous inquiry. And I'm afraid that, you know, if you have freedom of information, you will have people asking for information that does not exist, that you cannot provide, etc. But there are limits to what information they can have anyway. You can't have information that involves national security. And that's quite a range. You can't have personal information. You can't come and say, is it true that the Attorney General has cancer or something, you know. You can't come and find that information anywhere. I say that because I sincerely believe you do not have, so it's, if you can.
I'm grateful for the vote of confidence. You know.
Well, I hope I'm not wrong.
Next time I have a checkup, I can carry you.
No, I still think that, incidentally, we always think within the public service that we need more people and that any other service that is required of us is going to be, you know, too much. I don't believe that. I believe that we have normally a handful of public servants who are very dedicated and who do a lot of work, but we have a lot of slackers. It's about time they function. I can say this because I have no political standing, and I have no desire to have a political standing. But I was a civil servant myself. Huh? No, I was definitely not a slacker. And I can name a number of other people who were not slackers as well. I'm not going to name any slackers. I remember distinctly when I was in education, there was Frankie Jordan and Rudolph Goodrich, who were magnificent people. I mean, they really worked and moved things. But I also remember that once, something that I dealt with that was supposed to get to the permanent secretary did not get there for a year. Okay? That is a reality. I'm not... I was once asked, after a document in Spanish had gone around 1 million times, to do a free translation. I did a free translation. And then some very bright spark writes on the file, this is a very free translation. Somebody who could not have translated it themselves, you know, but they know it's a very free translation. That is the sort of thing I'm talking about. And putting a little bit of pressure doesn't hurt, especially now when we all need to put a little bit of pressure on ourselves. I think you would agree with that. Yeah.
Well, Mr. Marvin, as I said, you would find no contradiction from members of the panel in terms of the need for other pieces of legislation. And I can give you and the public of Barbados the assurance that the Freedom of Information Bill is receiving the urgent attention of the Attorney General and other similar pieces of legislation. We too believe that that they all have to work together. There's no point having legislation which will buttress our efforts in the fight against corruption if we are not prepared to open up the vaults of public life and public governance to the people of Barbados so that they can inspect them. And it is, I believe it must be a maxim by now that sunshine always chases away corrupt agents. I don't know if it's the healing nature of sunlight, but it certainly is that if you shine light on the activity of individuals, they are less likely to commit corrupt acts. Mr. Marvel, let me thank you for your presentation. We did look forward to hearing you with some enthusiasm, and you've not disappointed us. And I hope that if there are any other matters that come to mind in relation to the bill, that you'll feel free to send us a little note. We noticed that you sent a good old letter and not an email, but that's a discussion for another day.
Email, I just didn't know which email.
Thank you very much, sir.
You're welcome, thank you.
You feel free to stay with us for the other presentations.
Okay.
Mr. Williams. Mr. Williams, welcome. Our practice is to allow the persons appearing before the committee 15 minutes to present. Thereafter, the members of the committee will engage you as they feel necessary. Your rich tradition as a community activist, a person involved in the cultural industries, and also a distinguished former member of the lower house commends your words to the members of the Joint Select Committee, and therefore I give you the floor.
Thank you. First, let me express my appreciation to the Select Committee Chairman, yourself, and members of the That's it? Thank you. Can you hear now?
Closer still.
Much closer, or much louder, Rich. All right, let me express my sincere, thank you. Let me express my sincere appreciation to the chairman and members of the Integrity Select Committee for giving me this opportunity to put my feelings as well as some of the concerned citizens of Barbados here and overseas. What is extremely important that I've done this presentation in the introduction, the presentation, the perception, the idea, and also recommendations, solutions to move us forward. My feeling on this, sir, is that corruption has been all across Barbados for years. Within recent times, we realize that it has now become something of a talking point, and is something along the line that it affects mostly the people in public service. That is to say that politicians have been carrying the bulk of this, abuse. Government officers have been carrying the bulk of the abuse, and it seems that all along, as far as I'm concerned, that the corruption is actually delivered, birth are delivered by government politicians. The perception in this society is that politicians are the corrupt people, that government officers are corrupt, that as long as you have something to do with the government, you are corrupt. This is why I'm at the point, sir, that somewhere along the line that the private life in Barbados seems to have gone free of this corruption in relation to what is taking place today. And I think that most of the corruption comes by people who are involved in corrupting those people who are not corrupt. That is to say that We've got a society, not a society of the 40s or a society of the 50s anymore. We've got an up-to-date society. My memory goes back to tell me that in the early days, the politician was tampered and the vestry system was tampered with by people who could afford to tamper with it. This is an age now where we have moved forward from being members of the United Nations to being members of the Commonwealth Association. We are now world known, but things that we are involved in, and we're sitting and not understanding that the people on the outside of us in here are the people who are affected. That's why I'm dealing with perception. Perception tells me exactly that the people on the outside believe that the politicians are guilty. And as long as you're involved with anything government, you are guilty. Somewhere along the line, it's a feeling by the people outside that politicians receive kickbacks, that people in government service receive kickbacks. Now, these kickbacks could only come from people in the private sector. And there are people in the private sector that are only interested in themselves, the wealth, the pockets, and as far as they're concerned, as long as they get what they want, who they contaminate, and who they're dirty, as far as they're concerned, it is what they're up to. I say that to say this. Politicians have found themselves involved in political parties, and I'm not naming any one political parties from as far back as I can remember, have been used as pawns by some of those very people for the advancement in public life and for deepening and welfare and making them rich in terms of giving candidates, giving political parties, getting involved in the election process. So that because they're getting the election process, they now become gamblers. I call them political gamblers, these private sector people, because they get involved in election process with an idea that at some point they will receive the benefit of the involvement. That is, you put money in the bucket with an expectation that you will get called when the time comes for position. No, this is anything that we are supposed to run away from. This is a fact. I don't want to use personal experience here. I just want to say that it isn't fair for us to believe that the public does not have a perception. The public have a perception. Mostly I heard an attorney last night only said that the rulings now, judges refer to English rulings. Judges refer to this, they don't refer to what is happening in Barbados. Now, we have to refer to what is happening in Barbados. We have to refer to the fact that when you pick up Facebook, people's lives are at the brink of being destroyed because of some person at that end who doesn't care about that person, decided they're going to write whatever they like about that person and destroy that person's life for the balance of it. So the public see this integrity legislation not as politicians alone. And we cannot sit and just embrace and protect government servants. We have to go after the private sector. The private sector is more guilty than the actual, because the private sector are the ones who are full of corruption. The businessman goes into the public sector in order to advance his business, in order to advance his finances, in order to make sure that he lives at the life that he wants to live, to wine and dine and enjoy life at the expense of the politician. That is why people over the years, and no politician steals money, get this straight. I've been able to tell people that politicians don't steal money, they may be there for a kickback. The same way the politicians are there for a kickback, the private sector people are there to provide what I consider to be the seat. They're gamblers, they're political gamblers, and in the long run, the support of one party or the other tells you that they support one party with an object that when the time comes for them to turn against that party, they move to the other party for advancement. Why am I saying these things? I'm saying these things that over the years, I have seen private sector get involved in the idea of contracts. Private sector get involved in the idea of being placed on government boards. Private sector contaminate various people within the sectors to suit themselves. So the public sector, as far as I'm concerned, are the ones who are gullible, who are the ones that should be protected. I agree with that. But I'm also saying that we cannot have a legislation that deals mainly with the public sector. We have to have the Barbados Integrity Bill 2018. And I say that to say this, that the bill must spread over the private sector and the public sector. That the private sector is just as evil or more evil for contaminating the public sector, and they should not be running scotch-free. They should not be providing what they consider to be the padded invoices, where invoices are padded for their own benefits, and then the final analysis is that somebody within the public sector are guilty of conveying this type of behavior through the system. Let me just come back here and express what I've observed and probably leave it at that point, that politicians have got to be honest with themselves. Politicians have got to face the music and understand that across Barbados over the last 10, 20 years, that the public of Barbados seem not to trust the politician. And until politicians accept that they are embracing the situation where they need to start to defend themselves, this is why we are faced with a public bill, more so than a Barbados integrity bill. And I personally believe, and people who I've spoken to, as far as the perception is concerned, believe that both parties should be involved in this bill. That the bill should be to the point where that if someone from the private sector is found guilty of corrupting someone in the public sector, that somewhere along the line that the penalty, because they accomplished, the penalty should be just as great as that person in the public sector. Politicians must also understand that private sector people join with them in partnership for their own personal gains. And the personal gains is to create the lifestyle that the public of Barbados do not see or should not see a politician being involved in. Finally, police and custom officers come from the private sector. They eventually end up in the public sector. They're all part of us. So I don't see how you could separate a group of people who could be considered as being part of a society that can be contaminated by deep pocket people, political gamblers, and corrupt people. I put my case at that point.
Thank you very much, Mr. Williams, for your submission. If any members of the panel have any questions for Ms. Zeng, Ms. Senator Cummings.
Thank you very much, Mr. Williams. I want, of course, to express our appreciation also to you, as I did to our previous presenter, Mr. Marvel, for taking the time out to come today and to share this presentation. I think, obviously, having served in the lower chamber of Parliament, you have a unique perspective which is of merit, and I think we're appreciative of your input. You raised a couple of things that I do want to press you a little bit further on in terms of giving some additional recommendations and views. I think you and several of the presenters who have appeared before us in this setting and in previous sittings continue to make reference to elements of the integrity system. And I say integrity system because if we look at what Transparency International has done globally, they've developed a national integrity system that treats to both public life, which this bill covers, as well as a number of additional areas of coverage. And you and many others have spoken about two of them. One of them, obviously, and you speak of freedom of information, and that covers the media and others. But you also speak of the business community and of the private sector. And I wanted to hear from you what your thoughts are on ensuring that this bill, perhaps in its current form, because it speaks specifically to public life and public officials, what it should be complemented with in terms of other items of legislation to treat to some of the issues that you have raised. So I believe when the Integrity Group of Barbados presented, they talked about a number of other ancillary items of legislation that should be incorporated into an overall integrity system in addition to the integrity bill. And they would cover some of those issues that you've raised. How would you recommend that the committee treat with the question of private sector corruption, which is an important issue? What would be some of your recommendations?
I heard one of the members of the committee a little earlier talking about bits and pieces of law that go here and go there, right? Obvious if a country has to be governed, it has to be governed by laws. There have to be barriers to prevent those lawbreakers. In here, you're called to consider yourself as lawmakers. I don't want to put you in the bracket of lawbreakers. So the whole thing about it is that I believe that the bill is centered as, I've seen it and I've read it, as the Barbados Integrity Public Life Bill, 2018. In order for us to embrace almost every aspect of corruption and evil, I think the law has got to spread outside of public and go to private. And I'm suggesting that it should be known as the Barbados Integrity Bill 2018. Because if it is known as the Barbados Integrity Bill 2018, it means that public sector and private sector would have to remain within the armpit of the law. And those persons that I've mentioned earlier who find themselves involved in trying to corrupt the system would understand that the criminal law of Barbados falls within the same Integrity Act.
Just to follow up then, under the national integrity system developed by Transparency International, aside from entities in the private sector, they have a number of other agencies and groupings that they believe should be involved in creating a national ecosystem around integrity, and it includes political parties. And you mentioned earlier that both political parties needed to address this, have needed historically to address this question. What would be your recommendation on the inclusion of measures to treat two political parties as well?
The recommendation would be that as far as the political system of Barbados, and I'm going back, as I said earlier, that corruption traveled through the years as far as politics in Barbados is concerned, and the bulk of the blame ended on the footsteps of the politician because there was no integrity legislation. I'm saying if we're going for integrity legislation, those persons who were the offenders, who stood in the background and benefited by using people to create what we consider to be dishonest deeds for their own personal gain, that those persons are also part of the corrupt system and they should not go scot-free. We have known people who never face the law courts. We have known people in this society whose family has never been destroyed. Politicians' families have been destroyed and people stay in the background scot-free. I am saying that this should not be allowed any further. We are lawmakers, not lawbreakers.
Okay, I'm just trying to get a summary conclusion for the purposes of our own records. And it sounds to me as though I'm hearing you say, without necessarily saying it in those words, that the legislation as is needs to be broadened, or that there needs to be relevant legislation to treat to the issue of corruption in the business community, outside of those persons in public life. Because the bill as it stands now speaks to persons in public life. But you are proposing treatment equally for persons in the business community. And also, you sound to me as though you're speaking to the engagement of the public, because obviously you're talking about things like defamation of character and those kinds of things, how those issues already legislated can be treated to in the context of integrity. Is that what is that what we can capture?
Right, yeah, I agree. The more laws that we can have, which will fall within the same integrity, because I say that to say this, and I hope I'm understood of what I'm saying, right? That as far as the integrity bill is concerned, I have not read inside, I have not read the penalties. I'm saying that if we create a law in Barbados that spreads outside of the public, where the penalties are severe, where we investigate and not investigate with ordinary people, I have the strong belief that, and I've heard about whistleblowers and this thing, nobody's going to come forward as a whistleblower unless they are going to be protected. Secondly, this is a small country. Everybody knows everybody, either by family or connection. You're not going to get to the end of the bucket if you're going to ask your own people to investigate your own people. And I think that we have reached the point now where Barbados is now known worldwide. And all types of people come to this country either for vocation or with evil deeds. We have to look beyond our imagination that local people can investigate local people. We have seen this going on over and over where, because local people are investigating local people, people are asking the question, why this, why that? I believe that if we have a question to ask, that we are members of United Nations. We are members of the Commonwealth. And the same way we can talk about forensic investigations, I see no reason why we could not have forensic experts from United Nations or forensic experts from the Commonwealth to go into matters, serious matters, as far as the country is concerned. In terms of employing people to investigate people, my feeling about it that we will always be spinning top in mud. And if we continue to spin top in mud, the society will always believe that certain people in the society go scot-free, and others are contaminated, and others must pay the price. We have to embrace the whole tree in order to solve the problems that we are going through at this particular moment.
Thank you, Mr. Williams, and thank you for coming and presenting as well. It seems to me that the provisions of the bill as proposed respond to the issue of breach of public trust by those who are vested with that trust, which is normally the public official. You seem to be making a case for the private sector to be captured in that context where we are dealing with notions of breach of public trust. I need to hear you more effectively make a case around that issue, that concept of breach of public trust by persons in the private sector who in their private business operations entice, engage people in corrupt practices. I understand you to be saying this bill treats to the public official, but that corruption starts on the other side of the coin, the other side of the issue, in the private sector of those who you call them gamblers, those who seek their own economic advancement and interests over that of the state and over that of the integrity of the public officials that they target. And therefore, you seem to be saying that this bill as it now stands does not treat sufficiently to that aspect of this evil that we're trying to address. But my concern is if the notion of public trust is central to this, the provisions of this bill, how do you establish more effectively the case for capturing the private sector in greater fashion in the provisions of the bill?
I have a very strong belief that what I've just heard, that the private sector does not seem to fall into the categories of this public sector as far as the penalties and as far as the bill is concerned. And I also have the strong belief that the private sector is responsible and has been responsible over the years for contaminating the political system. That is to say that innocent persons, as far as politicians, don't get involved in exercises. But politicians over the years have been carrying the bulk of the blame. Why are you saying that? I'm saying this because if that was the case, and we had laws in place to find out exactly the person who gets the contract outside of the person who put in a ballot tender. Imagine two people are tendering for one job. And the person tenders less money, but that person gets the contract. You have a situation where in this country that certain people are beneficiaries of the corrupt system. They are beneficiaries of the corrupt system. And the corrupt system means that this lifestyle that some of us have, and some of us believe that somewhere along the line that after convincing yourself that that is the right lifestyle, you then realize that you have been moved into a position to satisfy certain people. Let me say what I'm saying. I'm going to say, no serious law-making, law-abiding politician who is working on behalf of honest people within his constituency, which is the majority, have any right at all embracing drug pushers and corrupt situations within the society. Because as long as you start to go down that road, what you're actually doing is that you have just conveyed a misconduct. Your trust as far as the people in the country is concerned is that you are not a serious and honest person. I'm not saying that they're not dishonest politicians. I'm saying that somewhere along the line that we, and I'm using the word we since I was involved in the system, that the politicians have been taking the bulk of the blame. When in true, in fact, the private sector people are responsible. The private sector people are the people who provide the bills, who pad the invoices. Who pad the invoices. And in padding the invoices, it means that somebody at the other end are going to be beneficiary of those invoices. So if you find that, then everybody that involved in this exercise you're going to accomplish. So whether it be a politician, whether it be a permanent secretary, whether it be a timekeeper, as long as that person is within the public service and they're contaminated by the private sector, they pay the price.
Thank you very much, Mr. Williams. Mr. Williams is now available for engagement by members of the committee. Oh, that was it, okay. Ms. Williams, thank you very much then. Is there any other question for Mr. Williams? There being none, Ms. Williams, you're of course invited to stay with us. We have one more presentation from the Barbados Bar Association. Yes?
Barbados. And as explained by the leader of the opposition, that they don't have the feeling that the public integrity bill stretches as far as it should be, that it should be expanded to involve what can be known as the Barbados Integrity Bill 2018. That's the case I put it.
Thank you very much, Mr. Williams. And as I said, feel free to stay with us for the other presentation. We now invite the representative of the Bar Association. Representing the Bar Association is Mrs. Kay Williams, and the submission of the bar, I believe, has been circulated. Yes. Ms. Williams, good afternoon. Your submission is long, 36, 36 pages.
Indeed, we have distilled them into key recommendations, 5 key recommendations.
Okay.
So we do not intend
To go through the, well, we will still give you 15 minutes to make your presentation, and then the committee will engage you. You have the floor.
obliged to you, Chair. Good afternoon to the members of the Joint Select Committee. And first of all, we'd like to say that the Barbados Bar Association is indeed very pleased to be able to be offered this opportunity to offer feedback on this very important piece of legislation. My name is Kay Williams, as you had heard before. I am a member of the Council of the Barbados Bar Association and convener of the Law Reform and Legislation Committee, who worked alongside with the President to prepare the submissions, to field comments from our members and prepare submissions. Now, this important piece of draft legislation repeals the Prevention of Corruption Act, number 31 of 2012, and promises to establish a regime, including an integrity commission, to promote the integrity of persons in public life and strengthen measures for the prevention, detection, investigation, and prosecution of acts of corruption. Whatever the association's concerns might be about the individual aspects of the bill, and whether it effectively achieves its intent in its current form, the Barbados Bar Association welcomes the introduction of legislation to govern integrity in public life. The ethos or guiding principle of the bill which thinkers and academics call the public trust principle, is that persons in public life, the institutions of government, and the officials of government exist to serve the interests of the Barbadian public. Public officers therefore carry a serious responsibility and duty to this nation, and they must commit to discharging their functions with integrity, fairness, and accountability. Furthermore, the public of Barbados and those who invest in our economy have a right to expect the highest levels of integrity from public officials. The public is also entitled to expect responsible and proper exercise of public power, which is fundamental to the operation of the rule of law. The association therefore recognizes that this legislation is a significant shift in the tenets underlying the public service. Once passed, there will no longer be a mere expectation or just an understanding, but rather a binding framework to safeguard integrity and to establish accountability. We sought feedback from our members, and the Law Reform and Legislation Committee conducted a comparative review of regional legislation. When the proposed bill was benchmarked in this manner, it was noted that the bill proposes a model which is similar to jurisdictions such as the Turks and Caicos Integrity Commission Ordinance number 8 of 2008. We also looked at the Cayman Islands, the Standards in Public Life Law, and the Bahamas Integrity Bill of 2017. In respect of the powers of the Commission, we realize that these later models go further than the earlier legislation which was enacted in jurisdictions such as Antigua and Barbuda, Trinidad and Tobago, and Grenada. It is indeed important to establish a statutory regime and a regulatory authority to set and maintain standards of conduct. But it is equally important to demonstrate by legislation a zero tolerance for breaches of that standard, and the need for sanctions which clearly indicate the rejection of a substandard conduct. The submissions before the Joint Select Committee, as you have noted, Chair, treats chronologically with each section of the bill, and then it reflects our membership feedback and considerations. So we have distilled our presentation today into a number of key recommendations which we would wish to highlight, just 5. 1, we note that the bill seeks to confer wide and coercive powers on the proposed Integrity Commission. A note of caution must be sounded, because coercive powers must only be exercised with the necessary restraints. Otherwise, the Commission will be open to legal challenges which may encumber its work and its effectiveness. Secondly, following the model of Turks and Caicos, the bill proposes to confer the power of arrest on the Commission's investigative officers. The investigative officer, we noted, had the power of a constable to arrest any person whom he, meaning the investigative officer, reasonably suspects has committed an offense punishable by imprisonment. The view of the Barbados Bar Association is that the power of arrest must be subject to the requirement that an investigative officer obtain a warrant from a magistrate. In the alternative, the power of arrest set out by the bill should remain the preserve of the Royal Barbados Police Force, preferably of high rank, as there are constitutional responsibilities concomitant with the role of a police officer and the execution of an arrest. In the model proposed by the Bahamas Integrity Bill of 2017, the Director of Public Prosecutions, upon receipt of the reports from the Integrity Commission of alleged breaches, can undertake criminal proceedings against the person for breach of the provisions of the Integrity Bill. Our third recommendation is that the bill establishes a number of offenses and penalties in the event of an adverse finding of an act of corruption. The penalties in the bill are wholly inadequate as a deterrent and must go further. It is understood that serious offenses of extortion, bribery, and coercion are criminal in nature and are grounds for prosecution. However, the bill stops short and fails to propose a system for lesser breaches. The current structure of the bill appears to be that once there's no adverse finding of corruption by the public official, then lesser breaches are not captured by a system of penalties. If indeed the purpose of the bill is to maintain the highest ethical standards among public officials, we believe there must be provision for lesser breaches of the Code of Conduct. Our fourth recommendation is that there is support for the inclusion of the Office of the Governor General in the bill, as it speaks to the fact that the proposed Integrity Commission will be operating at the highest level of governance. It is noted that the bill places a number of responsibilities on the Office of the Governor General. It is the view of the Barbados Bar Association that the Office of the Governor General must be adequately resourced to carry out the mandates of the bill if and when called upon to act. These resources must be provided from the highest level. They must be clothed in impartiality and insulated from any possibility of interference or bias. Such resourcing and funding should be established and kept in as independent a manner as possible. Our fifth recommendation touches on what the esteemed Mr. Marvel and Mr. Williams also mentioned, and that was brought up in the discussions, which is a call for supporting legislation. We had a call for the Contractor General legislation, and for us, one of the really important parts for us is creating an atmosphere where persons or private citizens, if they wish to make a disclosure about the actions of a public official, there is sufficient protection for them under this bill. The provisions of the bill, as drafted, provides for whistleblower protection for public officials, and this is understood within the context of this particular piece of legislation. But of course, if there is protection for the public official, what protection exists for the private citizen? If a private citizen or an employee in a private company wishes to make a disclosure about the actions of a public official, there's no protection for the average Barbadian under this bill. And our call is for supporting legislation, not for it to necessarily be included in this piece of legislation. The right of citizens to report wrongdoing is linked to principles of transparency and integrity. It is time to create and support an atmosphere where Barbadians, whether private citizens or public officials, feel free to report wrongdoing. This will serve as a key means of enhancing openness and accountability, both in government and in corporate workspaces, and supports the rule of law. It is recommended that priority be given to providing a comprehensive legislative framework to make all workplaces, including private sector, accountable to protect whistleblowers. There should be mandatory provisions in private sector organizations, whether of a certain size or otherwise, to set up whistleblowing mechanisms and have minimum standards and minimum protections for such mechanisms. Well, that concludes our 5 main recommendations. We have a comprehensive report before the Joint Select Committee. And once again, we wish to say and reiterate that the Barbados Bar Association is appreciative of this invitation to participate in the crafting of this seminal piece of legislation which is integral to and a cornerstone of good governance. Thank you.
Thank you very much, Ms. Williams, for your fine and erudite presentation, and it is buttressed by a clause-by-clause analysis with specific recommendations. The panel is now invited to engage Ms. Williams.
Thank you very much, Mrs. Williams. Thank you to the Bar Association for taking the time to prepare for us what at best could be described as one of the very comprehensive presentations that we have received from stakeholders over the course of the sittings of this committee. So we are very appreciative of this level of detail because it will enable our work when the committee concludes its public deliberations and then proceeds to consider the actual legislation itself. I do have two questions specific to number 3, your third point in your executive summary. It speaks to the issue which you raised about the failure of the bill to propose a system for lesser offenses. So in the event that you are investigating a significant allegation of corruption and you are found not to have done so, that there is no provision for a lesser offense. Could you elaborate a little bit more on that, on what you would like to see for the benefit of all of the members of the committee, but also since this is a public hearing, and I think that the speaker who went before you very correctly said that the public of Barbados is very engaged in this particular matter, especially at this time. And so it's important for people to be able to hear the specific recommendations that you would want to make in the event that we don't get the high-level convictions.
Yes, thank you. Now, looking at the legislation clause by clause, we looked at the offences set out in sections 54 of the Act and the presumption of corruption. Now, one thing that the Joint Select Committee may notice is that there is a repeated call to see the regulations and the code of conduct, because perhaps many of the concerns that are raised may be addressed if we had the benefit of seeing the regulations and the code of conduct. The concern was, of course, the bill sets up criminal penalties. If I could just turn to section 54 with your permission. And defenses with respect to any act of corruption are what will be deemed as corruption in respect of the act. So the offenses are such that if a person commits the act of corruption, they will be subject and is guilty of the offense. So we presume, therefore, they have gone through the necessary process to be found guilty of the offense. Then we are dealing with penalties on conviction, either summary or on indictment. The concern was sometimes there may be a breach which may not be as egregious to be an act of corruption, but which by its very nature, of course we're dealing with public officials and it's in the glare of the public eye, may be an indiscretion, a breach, an oversight, which really at the level that the public officials are operating at, we expect more. It may not actually fall to be considered an offense, whether on indictment or conviction, or the particular official who has been charged, there may not be a final finding or final conviction. The question is, if there is a lesser breach, it may not be a conviction. What exists? For the public, of course, they will say, but look, at the end of the day, this person was not made subject to a penalty or a fine of any sort. The way that the legislation is worded, you must have a conviction. But there doesn't seem to be room in between there where indiscretions or breaches that appear not as egregious but are blatant are somehow sanctioned. And perhaps, again, we're coming back to public perception and the need for the public to feel that there is a consequence to your action, whether the action was done willfully or whether it was done negligently. The public needs to feel that the public official does not get away with what we would call just a slap on the wrist.
Thank you very much, Mrs. Williams. Now to my second question, which is specific to your whistleblower protection. Now, you have gone further than I think any of the other presenters before, because we have heard multiple persons speak about the importance of private sector coverage and the
Yes.
treatment of the private sector in legislation, whether in this legislation or in related legislation in support of what is being sought after here. But you have spoken here about the importance of the private citizen and the role of the private citizen in drawing attention to criminal offenses, criminal acts by public officials that they may be privy to. So if you go to participate in a particular transaction, to conduct a particular transaction, and you find yourself being asked for a fee that is not a legal fee, what does that private citizen do? And you have said here in your presentation that that is not currently covered by this legislation.
Nor can it be.
Nor can it be. So again, it raises the question that there is perhaps a need for additional ancillary related items of legislation to go along with this in order to make it effective. And that some of the issues that should be treated with in those ancillary items of legislation should be, so far based on what we've heard, the private sector, the business community, freedom of information, and of course, whistleblower protections, and I think there was a reference earlier to political parties, not in your presentation, but in others. So from the Bar Association's perspective, is that something that you would be supportive of, the development of additional items of legislation which will be complementary to a holistic national integrity system? Because you also mentioned Transparency International, and they have the national integrity system and the overall ecosystem. Is that what you would ultimately be proposing to the Select Committee?
Yes, certainly. In general, the Barbados Bar Association is supportive of this legislation and any form of legislation which promotes integrity, not only in public dealings, but in commercial transactions, whether private sector or public sector. Now, when it comes to the issue of the private citizen, there are two ways to go about it. Just one moment, please. Sorry, there are two ways to go about this. There is the thought that there ought to be stiffer penalties, even among the private sector, where persons are dissuaded from being a part of a transaction that is not of the highest integrity. There is not another view that perhaps on the end of the private citizen, that we should create an atmosphere of whistleblowing, where the private citizen feels comfortable to be able to report in certain incidences or certain things that have come to their attention, and yet they feel protected. So either you create a system of greater penalties, but there's a feeling that if there's greater penalties on the side of the private citizen, or even on the commercial side, that it may stifle or stymie people coming forward. Our view that we are proposing is create an atmosphere of whistleblowing where you may be several layers deep in a transaction and you're saying something's not quite right here. And you do not necessarily have the ear of the person at the top of your private commercial company to say that I am very concerned about what I'm seeing. That person, whether employed with a company or whether it's a private citizen in a transaction, would they feel protected if they had a mechanism by which they can report these things and still feel protected? The question is, which system would we want to implement for our jurisdiction, for our nation? Bear in mind, we are a small jurisdiction, so we may be trading certain actions for anonymity. So so you have to be very careful which system you think works best for our economy.
Yes, Bishop Atherley.
Thank you for your contribution as well and for the interest of your association in this matter. Your first recommendation had to do with the element of coercive power. And you did express the caution that the coercive powers enshrined here should be matched by adequate restraint.
Yes.
Is there any expression or any aspect of that coercive power that you can identify for us which you consider now to be not so matched by the necessary restraint?
We mentioned in what the first one has to do with the investigative officers. I'll turn to that. There was a concern that the investigative officers held a lot of power. We understand that this piece of legislation is not alone. The Turks and Caicos model also has investigative officers who have the power of arrest. The view that was posited was that the investigative officers are appointed by the commission. They, in turn, have the right to, let me just pull up that part. They have the right to Section 15 of the Act. An investigative officer has, in carrying out his functions, and of course we understand the functions are delegated to him by the commission, they have the power of a constable to arrest any person whom he reasonably suspects has committed an offense punishable by imprisonment. And then that officer shall, after making the arrest, and interestingly, the Turks and Caicos model says, shall, after making an arrest, immediately deliver the person arrested to the custody of the police force. This does not have the word immediately. Here we say, okay, the commission delegates to the investigative officer that power of arrest. How is that power of arrest? How is it executed? Will it, at the end of the day, will the manner in which the investigative officer makes the decision, because it's someone whom he reasonably suspects, if that person is delivered to the police force, who then brings them before the magistrate, would the investigative officer be able to meet all of the evidentiary requirements when it comes before the court? So we just want to be clear that the investigative officer executes the power of arrest in a manner that keeps the commission out of any quagmire with respect to any concerns with respect to custody and concerns with respect to the actual arrest and the execution thereof. There are models which say that the commission, well, this legislation also does. The legislation also says that you can use I believe, bring in the powers of police at any point in time. There are models that specifically leave the power of arrest to the police force. And we want to make sure that you don't have a commission where an investigative officer that has a misstep or exercises that power in a way that the commission finds it's being challenged. Now, there's another aspect. It has coercive powers in Section 16 for production of documents. The investigative officer can apply to the judge in chambers for production of documents. The investigative officer also has applied to the court and get an order for the power of search and seizure of documents. And again, if the search and seizure involves a commercial entity, where we know that with search and seizure operations, there's always the issues of indemnity and liability with respect to the search and seizure. Again, how is the how is this coercive power fettered? Again, when we see the regulations, maybe it might answer a lot of our questions and so on. And we don't know whether we want the Integrity Commission necessarily to be in the forefront of legal challenges with respect to these same coercive powers. Would you want to delegate that to the police force so that if there is a misstep, if there is a legal challenge, the challenge goes on, but the work of the Integrity Commission continues unabated, rather than the Integrity Commission themselves, through their investigative officers, actually exercise power of seizure and power of arrest. That was one of the main concerns coming out of the comments that we fielded at the time.
Thanks, Chairman. Ms. Williams, you mentioned just once in your presentation the code of conduct. I'm here looking so far for somebody to support me in my view that this code of conduct should be legislated rather than done by the commission itself. I'm hoping for support. Because in this legislation, the commission is supposed to draft the code of conduct. I do not agree. And I wonder what is the views of the Bar Association in respect of that provision. I see in the Public Service Act, they have a whole set of codes, and they were legislated in Parliament, and we follow those codes. I don't know what is so special now about the commission itself drafting its code of conduct. I thought that we would have want to understand what is the will of Parliament and put it in the legislation rather than have the commission to come up with their own ideas. What are the views of the Bar on this?
The view of the Bar with respect to the code of conduct, we didn't have we weren't opposed to the commission producing that code of conduct. The issue was that even as 20 years ago, we would not have known about the cloud, for example. Sometimes when you create a code of conduct, there may be a set of circumstances which we cannot foresee. And it was felt that the code of conduct ought to be subject to periodic review so that it adequately captures the what really is prevalent at the point in time. The other issue with the code of conduct is whether, and it's just a question, whether a public official or someone who is in the list of persons here, you are already in your post and appointed, and then you legislate that code of conduct, you have to make sure that there are no challenges with respect to someone thinking, but maybe you have varied certain parts of my, certain terms of my employment if you legislate the code of conduct. It is something to which they must adhere. We appreciate that, and I think that is generally accepted. If you legislate that and then you have to tweak it, you as you know, it's always a bit more cumbersome to be able to make those adjustments. We could be wrong, but our feeling was by having the commission create the code of conduct, the one thing that the commission ought to be responsible for or commit itself to is to frequent review, whatever that periodic review may be, every 5 years, every whatever, but there ought to be a review of the code of conduct. And so to that extent, we had not proposed a legislative framework for the code of conduct, but it is something that certainly can be given more thought.
Thank you.
Just a few questions for her, and I really appreciate the work that the Bar has done in going through this section by section. And I'm not trying to defend the work that we've done, but there are some areas that we've found from time to time the reading of them by I hate to say readers, produces a result different to what we think the statute is saying. So for example, your analysis of 9.3, you refer to it at page 10 of 36.
Yes.
Where you're saying that the commission is empowered to appoint investigative officers, but you seem to read 9.3 as prohibiting members of the police force from being appointed as investigative officers. I see it rather differently. I think that the section is simply saying that you will have investigative officers who will have certain powers. The mere fact that the investigative officer has those powers should not at all suggest that he is a police officer. So the way I read it, it says an investigative officer has the powers described in Part 3, but for the avoidance of doubt, is not a member
Is
of the
not a
police
member,
force.
yes.
So this is not to say that members of the police force cannot be recruited as investigative officers. It is simply saying that by virtue of having those powers, he is not to be considered to be working or performing the duties. He's not a police officer.
Understood, Chair. I
That's how
believe-
that's how the
yes.
drafters intended it to be construed, and that's certainly how we saw it. I know your concern about the possible abuse of powers, but in relation, for example, to the power of search and seizure, which you, Clause 17, and I think Clause 17 is discussed, page 17, coincidentally, 17 of 36. I wonder if your concern is well-founded, because the power of search and seizure is one that is exercised by an investigative officer after he has applied to a judge in chambers. Now, the normal power of search and seizure in the police force is not exercised upon an order of a judge. A policeman comes with a search warrant signed by a JP. I'm not going to say anything, but signed by a JP, who sometimes will sign 20 at the same time. And so there's no consideration given, we know this, of the specifics of the case, and the search warrant is executed, police search and take up. In this instance, the commission's functionary, the investigative officer, must actually apply to the court. And in a situation where he does not satisfy the court, then he can't get the order. So it would seem to me that you would be hard pressed to find a better protective mechanism than this process. And I don't know whether the bar considers that to be a sufficient safeguard, or whether the bar felt that there should be some process over and above the application to the judge.
Thank you, Chair. You have to forgive us lawyers. We live to find the challenges and the
I'm well aware. But
with respect to that section 17, after section 17D, we appreciate the fact that, of course, the investigative officer has to satisfy a judge in chambers. And that, of course, has its own tests and, of course, its own evidentiary bar and everything. The concern here was that the judge may issue a warrant authorizing an investigative officer to enter and search the premises for the material and to seize and retain any material that is in the opinion of the investigative officer. And we felt that, again, although the investigative officer had to go to the court for the power for the search and seizure, the determination on the spot as to the material that can be seized and retained, it seems to us, when we looked at the phrasing of the section, to go back to the discretion of the investigative officer as to what is to be seized and what is to be retained. And the concern was that perhaps the order should be a little more constrained. It can't be anything at large. And it should not be within the remit of the investigative officer, but rather it was for the court to determine the parameters of what is to be seized. So that was our concern.
Okay, and I thank you for that clarification, except that I'd want to point you a little further.
We appreciate that
To
also,
a
sir.
closer analysis of what follows after,
After that section.
because it says, the last three lines, so that the investigative officer, having got the court order, is entitled to search, seize and retain any material that is, in his opinion, but these are the governing words,
Of the
is
kind.
of the kind
Yes.
described in paragraphs B and C. So it isn't that the investigative officer can seize anything that comes to his fancy. He must make a determination that what he is seizing is of a kind described in paragraph B and C. If he goes beyond that, then obviously he has run afoul of the order. To my mind, when I looked at it, I felt satisfied that that was a sufficient safeguard. May I take you then to a discussion on the matter of a blind trust? I was
Yes,
interested in the comment of the bar. I well remember that, we try to categorize things. It was the judge who famously said that the categories of negligence are not closed. And we have found concepts of trust entering into the law over the years. Now, so far as my own research suggests, blind trust is not a statutory trust. It is a trust with particular legal characteristics. And those characteristics, it is from those characteristics that the term blind is applied to it. And it is just that there is a, what we in Barbados will call a blind between the administration of the trust assets and the person who puts the property into trust. So that blind trust really, in my mind, suggests nothing more than a trust which is created with an increased level of separation between the beneficiary and the trustee. So, as we all know, beneficiaries have certain rights in relation to trust property and so on, but in this case, what is being conveyed is that there must be an even greater degree of separation between the trustee and the beneficiary. So I didn't think, well, I understand that there might be some uncertainty as to what we mean by a blind trust. I think that there have been enough judicial decisions on the concept that we didn't need to define it. But I'm grateful that you have given us the definition of blind trust used in Trinidad. And thank you for your research. And we will certainly,
Thank you,
we will
Chair.
certainly seek to see if it is a definition that we would.
Just on that point, Chair, I think for this, I will say I spoke to one or two of the trust purists who felt that I believe the background for the comments stem from the fact that perhaps the time maybe has come to revisit Barbados' trust law. And I believe you understand, sir, what I'm talking about. The time has come to update the trust law. And they just wanted to ensure that an integrity in public life bill was not importing terms into the trust law that didn't have a support mechanism for it, or was perhaps already supported by provisions that made it quite clear. For example, one attorney said, well, the section 28.5 speaks of the assets being conveyed, and in a pure sense with a blind trust, it is purely contractual between the parties to ensure that there is no participation or that complete separation, but there's no conveying of the trust property. And this particular clause, section 5A, speaks about conveying. And they just wanted to make sure that it was supported by other laws. So I think that might be just a finer point, maybe, but, they
Except that I think that we know what we mean when we say conveyed to a trust company. Let me tell you what my concern about this is, and I apologize for monopolizing the discussion. I know Senator Tate is anxiously awaiting her turn. My concern would really be the requirement that in order to establish a blind trust, you have to engage a trust company.
indeed, sir.
Now, when we look at the category of individuals who are settled, who are named in the schedule as being individuals in public life and who would therefore have to file a declaration. I don't know that any, if any at all, but maybe one or two, but perhaps not, would be financially able to incur those additional costs. And I don't think that there's any sense in which the only time you can separate yourself from control of your assets in that way, I don't think that you have to have a trust company. And in fact, with my familiarity with the costs associated with trust companies and so on, I wouldn't want to put anything that I owned or controlled into a trust company. I don't think I could afford it. That's because I have very few gains. And therefore, you know, we may well be insisting on a requirement of a trust company in circumstances where our context doesn't allow. I think it's fairly well known that that the former Prime Minister of Canada, his last name was Martin. I don't remember his first name, but he had a large number of offshore companies in Barbados.
In Barbados, yes.
When he became Prime Minister of Canada, he put his companies in a blind trust, but he owned a company called Canadian Steamship Lines, one of the biggest transportation companies in Canada. So when you have that amount of assets, you can afford to engage trust companies. But Senator Franklin has indicated that he would wish me to become his trustee. He couldn't afford a trust company. Are there any other comments on the specifics of the bar's presentation? Yes, the Honorable Ralph Thorne.
Thank you, Chair. Mrs. Williams, I take it this is the work of a committee. A committee
Indeed, a
authored this
committee.
document.
Yes. indeed,
Right,
yes.
and that you're a member of that committee.
Yes.
Yes. Now, your namesake, Mr. Williams, and I don't wish to be unfair, but you heard him.
Yes.
And he came here today, and I think that he is suggesting that the bill is narrow in terms of the categories of persons that it intends to capture. Not capture literally, but cover. That is to say, persons in public life. And he feels that private persons who transact with persons in public life ought to be included in this bill. I don't know if you're following me. He feels that way.
Yes.
Has the bar addressed its mind to that issue as to broadening the categories of persons beyond persons in public life and to extend it to private persons who transact in a corrupt manner with persons in public life? Did the bar, I know it is not reflected in your final document, but may we ask if the bar gave any consideration to broadening the category beyond persons strictly in public life?
Yes, indeed, we did. We had quite a bit of a discussion on the second schedule and whether the second schedule even went far enough.
Yes.
Some persons felt that, for example, item 3, permanent secretaries and officers of related grades, that I know that those who are in public life will tell me, or those who are in the public service will tell me, related grades has a very specific meaning. But we just felt that in and of itself, there were a little too many nebulous areas and perhaps needed to be specified. The other question is, for example, chairpersons of boards. The question was, is it only going to be the chair of the board? What about the deputy chair of the board? How far should we go? The other, that's item 5, chairpersons of boards. Commissions, corporations, and other entities established by statute. For example, a school may be established by statute. Is it contemplated that the principal or the deputy principal then ought to be brought into this? And then we looked at the whole question of judicial office. It said magistrates, and we asked whether that goes far enough as well. When it comes to the private sector, I think our feeling was that this may not be the bill to capture the private sector. As we mentioned when speaking with Senator Cummins, we asked ourselves, what is it we want to promote? Are we promoting an atmosphere where persons are coming to report the wrongdoing, or are we going to create an atmosphere of greater penalties for the private sector? There's a feeling that in the private sector, those who are either in charge of companies, own companies, or those who are directors are given far too much leeway, and there really is no slap on the wrist, there is no code of conduct for them. There's nothing to which they must adhere. Obviously, they in turn have their own private code of conduct because their banking and other commercial activities require them to declare and disclose assets. We understand that part. But it doesn't necessarily mean that when it comes to dealing with public officials or public contracts, that the private citizen or the commercial entity will be penalized for having conduct that is below the expected level of conduct. Again, if there was a call by Mr. Marvel for the Contractor General legislation, and we believe that maybe there may be a need to have 2 or 3 pieces of legislation which would, in essence, require the highest level of dealing, both sides, private sector and public sector, to capture those private sector persons who interface with public sector, whether it be contracts or otherwise. I don't think this bill as framed is the one to do it, but yes, we do agree that it would appear that the private citizen as well as the private companies need to be called into account. And they are the ones, very many of them are also in public life, very much like these persons, and are we calling them at the level and at the same standard that this integrity bill and legislation is calling public officials to? That was our concern.
So that you're saying the reason the bar excluded them,
We didn't exclude them.
well, from your final paper here, they've been excluded.
What we did was we commented clause by clause. But again, that is something we are always willing to expand on. To be honest with you, there were, even as we submitted, there were still people coming with comments. So this is not finite by any means. And there are still a lot of areas of interest and concern that we will be very happy to continue to comment on.
You'd have to get leave of the chairman to do that.
Indeed.
Thank you.
Thank you, Chair. Ms. Williams, I have to come back to you because you started something and you just glossed over it with the judicial officers. You mentioned magistrates. What is the view of the bar with the exclusion of judges in this legislation? I remember one of the presenters said that the judges have some constitutional protection and you might be in breach of their constitutional rights and that kind of stuff. I don't believe that because the magistrates have the same protection. No, they have protection in the Constitution because the Public Service Commission, the Judicial Legal Service Commission deals with them.
That's it, sir.
And judges, you have to set up a tribunal to deal with them, but the Constitution still speaks to both. Now I'm saying if you exclude one, why not the other? And if you're going to exclude judges, I want to find out what the bar thinks about the exclusion of judges from this legislation.
Yes, we are of the view that the second schedule does not go far enough. There's a reason as well, we in our comments we said that there was a need for much greater clarity, and we actually took the time to show those pieces of legislation which went at length to include, for example, the Director of Public Prosecutions, to include legal officers employed by the state, that I believe that is Grenada. We felt that the schedule does not go far enough, specifically with respect to judges. The argument back and forth, and it's not reflected here because, again, we didn't have a final position on it. The argument back and forth was that, as you indicated, that the judges were subject to the Judicial Services Commission and fell under the Constitution. We looked at other pieces of legislation to see if they included judges as well. We did not find that. So what we did is that we were very specific to say, look at the other schedules and see how far Barbados wants to go, because we didn't think that this particular schedule went far enough, for sure. But yes, there was comment as well on the judges, but it was felt that the judges fell under a regulatory body.
Only that I think it went too far in including opposition senators. Oh, yes, and independent senators, it must be fair to them as well. You know, we are not paid, and we have to go and incur expenses to comply with this legislation, and the body compensating us for it. So I think that's going a bit far too for us. I know Ms. Tate would agree. I'm hoping she would.
Any other interventions? There being none, let me thank you and your members of the Bar Association for this very fine presentation. You can tell that everything that you have posited here, we don't necessarily agree with, but that is the essence of a healthy democracy, that dissent and opposing views are received in the spirit in which they were given. Please convey our gratitude to the members of the bar, and I'm especially grateful for this format, which will allow us to look at your comments on a section-by-section basis. Thank you very much. That ends our public deliberation. There are just two small matters that I want to raise with members of the committee, but we would discuss those.
Chair, unless I could be of further assistance, we may be excused.
I was about to excuse you.
Oh, sorry.
I was about to excuse you. Thank you very much.
I'm so
You
sorry.
can excuse
I
yourself.
travel tomorrow and
I know what that's like.
some pressure.
So if the committee can just meet in camera, so if the members of in the public gallery can excuse us, they're just two short matters that we have to deal with, and then we will adjourn.
Grateful to the members of the committee and to the chair. Once again, thank you very much.
Hot? Cold? Well, no, complain when the rains will come.